All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV14-0607, Lawrence versus State of Arizona et al. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side will have 20 minutes for oral argument. And Mr. Martin, as the appellant, you are responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs and we have conferenced the case prior to argument. So with those preliminaries, Mr. Martin, you may proceed.
Thank you. May it please the court, counsel. Good morning. My name is David Martin. I'm representing Wendy and Robert Lorenz. Wendy is the paternal grandmother of EC, or I'll refer to her as the minor child. She is present here today behind me, along with her husband, Robert, the paternal step-grandfather and husband of Wendy. Your Honors, we are here today to seek and ask the court to reverse the trial court's determination to dismiss this case under a 12b6 motion that was brought by the state. We would urge the court to conclude that under the particular facts of this case, coupled with the administrative regulations, the statutes found in Title 8, and the cited case law, demonstrate that there is first and foremost, a duty owed to the child EC and a concomitant duty that is owed to Wendy and Robert to timely extend to them an opportunity and a fair opportunity to be involved in the placement of EC, to be involved in the process leading up to the adoption, and to not, as was so egregiously occurred in this case, engage in extensive and insidious interference, frustrating and actually working to obstruct Wendy's efforts to gain early and meaningful access to her granddaughter.
Let me interrupt you, Mr. Martin, because you sort of lumped together duty to the child and duty to your clients, and I think they're two separate issues. We're obviously not dealing here with the child who's the plaintiff. I think we'd be having a different argument if we were. And so let's focus solely on where you can find any legislative intent in either the statutes you've cited or the DCS manual that shows that the intent was to benefit placements as opposed to the dependent child.
The duty that I refer to, or the concomitant duty that I refer to, owed to Wendy is to consider her for a placement. They are found in 8-514B2 in the least restrictive environment. They are found at 8-514.03A, the kinship placement to be promoted. They are found at 8-103B, which calls for CPS to develop essentially their service manual that I've cited to for the best interests of the child. They are found at 8-862H1 for a prospective placement with a grandparent is first mentioned.
But and I'm quoting now from the Arizona Supreme Court from the estate of Hernandez case, a statute or regulation gives rise to a tort duty premised on public policy only if it is designed to protect the class of persons in which the plaintiff is included against the risk of the type of harm which has in fact occurred as a result of its violation. And I'm trying to find where we can find any indication in the statute's regulation, or the manual I think is a non-starter quite honestly, but even lumping that in, where we can find any indication that the legislative intent was to protect kinship relatives in foster care placements against the risk of this type of harm. And I just can't see it anywhere. And the separation of powers notion is that we don't decide when you're relying on a statute, well, it's a good idea to include these other people. We have to find a legislative intent to benefit that class of persons and to prevent the kind of harm that you're alleging has occurred here.
The class of persons that the legislature intended to protect is the family integrity, as was so observed in the Betchel versus Rose case. Wendy and EC are a family. You cannot separate them out and say, well, these legislative statutes and directives and the regulations only go towards EC in a vacuum. They go to the family unit. The maintaining of the family integrity is what these legislative mandates call for. The kinship provisions are what we would submit the legislature intended, and it was so eloquently articulated in Betchel versus Rose as maintaining that family, albeit in an intervention case, but that case has also been subject to from some further consideration by other courts, especially in William Z, that it is fundamentally about the best interests of the child. To try to segregate and isolate just the child's interest and the child being protected versus those surrounding the child is an impossible analysis, because it takes a broader view to protect the best interests of the child.
Well, I don't think there's any disagreement about protecting the best interest of the child, but in getting there, isn't the real remedy at various points throughout, and if need be by special action, to force the trial court to consider what would be in the best interest, even if that meant whether these grandparents or other relatives, as opposed to once you get past that point, how do we then discern that there's then a duty that would give rise to a tort remedy?
In this particular case, you determine that a duty gives rise to the negligence and gross negligence claims by taking a look and considering the egregious conduct that was engaged in by CPS personnel ranging...
Let me interrupt you, because we know from Gibson versus Casey we don't do that in duty. Duty is not a factual inquiry. In fact, we're told by our Supreme Court not to look at the facts. We have to find it based on a special relationship of the parties, or, as you've alleged, based on public policy stemming from statute. So we really can't do what I think you're getting ready to ask us to do.
Thank you, Your Honor.
Though we used to be able to do that.
We did it before Gibson versus Casey, for sure.
Thank you, Your Honor. The class, the duty is found in the preferences, albeit just a preference, I understand that, but it is also found in the broader view of protecting the interests of this child. And if this sort of interest is not recognized, it leaves the door open for future cases to simply sweep aside the statutory mandates, the regulatory mandates the CPS was supposed to follow that were clearly not followed in this case.
Except I think what Judge Portley was also alluding to is you're not without a remedy. Unfortunately, your remedy didn't work out as you had hoped in the juvenile court and in the appeal of the adoption decision, but it seems like that was the place to make these challenges, and unfortunately that wasn't successful, and so it's not as if this is a wrong without a remedy.
Your Honor, in the process of the adoption trial, Wendy was told repeatedly by CPS representatives, by the representative, the attorney for the foster parents, and by the court herself, that the place to make the claim for the wrongdoings by CPS was in this case. So we are here. And to deflect back to the adoption trial, clearly we attempted to do that, and it was, quite frankly, probably not the place to be doing that. Your Honor, you mentioned and alluded to a special action proceeding. By the time a special action would have become ripe, she was not denied intervention, but by the time she got to the point where a special action could have happened, the factual background had already been set because they failed to afford the preferences and worked actively against them, thwarting them. So we would submit that the duty should be recognized as a concomitant duty that is owed to this child, without separating the child's interest and severing it so fully and completely from those who the courts and the policy of the state has recognized has a deep and abiding interest in raising the child.
You're saying it's concomitant, but clearly we know the statutes are designed to protect the best interest of the child, and you say then family members then get to bootstrap themselves to the child in the best interest so that DCS can't do the things they did in this case?
Not by bootstrapping. No, certainly not, Your Honor.
Okay, I'm just trying to understand that
Sure.
the separate distinction you're trying to draw because, Title VIII is really all about the child.
It is about the child, Judge, but the child's best interests cannot be looked at in a vacuum. The child's best interests are not being served by what happened in this case. They're not being served by avoiding and ignoring and not considering and giving fair consideration to the efforts of a grandparent and actually working against it.
Should we then find, kind of like what Congress has done with the Indian Child Welfare Act, find that they're placement preferences, even though there's lots of people arguing we shouldn't?
No, Your Honor, I don't think that is the case. I think that would run afoul of what the courts have said about what is the nature of the preference. Ultimately, it's trumped by the best interests of the child. But in this case, by not recognizing and accommodating and working against the efforts of Wendy to adopt, the best interests of the child were ultimately not served. And it is their rights, that my client's ability to be considered, fairly considered, is all that we're asking for, and she was not. Without some accountability on that, those kinds of things can and will occur in the future, and there's been no accountability. In every forum that we've gone into to try to seek accountability, we're told that it's in some different forum. So, no, I don't believe that it ought to be the sort of preference that ICWA provides for under federal law, because our state law has clearly indicated that these preferences are not are merely a preference and can be overridden. I see that I have about 8.5 minutes left. I would like to wrap up and save a little bit, but the point is that there is a duty to consider them and to fairly consider them. That did not occur in this case, and the notion by the trial court judge that we could amend and add a count of denial of accessibility really gets us nowhere at all, because the accessibility is so interwoven and a part of the fair consideration to be positioned and not thwarted in the ability to try to adopt when the time came. But that opportunity was lost. And when Wendy left and went to Saipan, she left with the belief that CPS would follow their regulations, their statutory preferences, and either reunite or, if not, look at Wendy as the basically first choice for adoption. Thank you, Your Honors. I'll reserve my time.
May it please the Court. My name is Brock Heathcott. I'm Assistant Attorney General here representing the state and the individual employees of DES who are defendants in this case. I want to say first off that we have no intention of intimating in any way that grandparents are not an essential part of a child's life. I personally did not know my grandparents very well because they lived on the other side of the country, but I know my parents have been fantastic grandparents, and I wouldn't want them to not be a part of their grandchildren's lives. And in some sense, we all have an obligation.
So is that a duty?
Do the grandparents have a duty to their grandchildren?
No. Does then DCS have a duty to ensure that grandparents play a part of a child's life when they've come forward and say they want to participate and be considered as a placement preference because the parents are don't have the ability to do so?
I believe there are regulations that do suggest that grandparents have a right to be part of their child's life. But that's not what we're here to talk about today.
Well, but that's what I'm trying to figure out. Are those regulations then the basis of a duty which would allow Mr. Martin's clients to proceed in this case?
Not in this case, Your Honor. It would allow
And why
them-
not?
Because we're talking about a tort duty.
Well, but if there's a duty, okay, then why does it matter about the forum, especially if the duty was breached by the people who were responsible for making it happen?
Absolutely, the forum matters.
There's a difference between the juvenile court and the grandparents being ignored and then having no remedy and trying to hold an executive agency accountable for their malfeasance.
Yes, Your Honor, the juvenile court has oversight over the agency, and the juvenile court allowed them to air their grievances and then made a decision. And that is the remedy that they have in this case. And the reason,
They don't have a remedy now, right?
well,
Those are over.
people don't constantly have remedies.
Okay. So we can cut grandparents off and just say, we screwed up, we're sorry?
Well, I wouldn't say you can cut them off, because they can continue to petition for the right to visitation, for example.
It's a hollow. Because we know under the Supreme Court precedents that as long as the child has two parents, that those parents, though adoptive parents, can say no. And there's nothing that can happen. So you're saying they should do something annually only to be told no, you know? That's no remedy.
Your Honor, I believe that is the remedy, because each time they make a petition, then there's oversight of the process to determine whether or not it's appropriate.
But unless there's some notion that the adoptive parents aren't, as Justice O'Connor said, the healthy parents get to make the call. It really isn't for the court to intervene, so it's a fool's errand you would have them do.
The answer is not a tort remedy, and I'll explain why. First of all, there's never been any such duty that any of us have discovered in the law that they're asking you to find here. The court is essentially being asked to create one. And it's not, I don't want to say it's a slippery slope, because it's not a slippery slope. It's a sheer drop into an abyss of tort litigation, because it's not just the grandparents who would have a grievance. And I want to point out that there might be 4 separate grandparents with contradictory assertions of rights in a particular child's case. But aunts and uncles and cousins and anybody else who wants to have an interest in the child would all be asserting contradictory claims, and somebody is not going to get the child. And as a consequence, if we open this door to tort litigation, what we're saying is that DES and CPS are going to be sued many, many times over decisions that they make in the best interest of the child. And
Well, it seems to me the first category under that parade of horribles you're reciting is the parents, because it seems to me if you accept the notion that a duty arises under 8514B, then the first placement preference is the parents. And so you would clearly be saying that any parent who was not reunited with his or her child could sue the agency. And I understand your policy implications, but as I did with Mr. Martin, trying to cut off a recitation of the facts, duty is a very narrow legal concept, and the way he has framed the duty issue is based on statutes, a regulation, and a manual. And as I said, I don't think the manual is compelling, but we have to be able to find from those legal matters the intent to benefit the placements. And so, to me, that's a pretty narrow focus in this case.
I would agree, and I believe the Antonio P. case is directly on point. I found it shocking that the appellant did not mention the Antonio P. case at all in the opening brief or the reply brief, because the Antonio P. case specifically addresses the statute that we're talking about, and specifically says that a preference is not a mandate, and therefore, in that case, the juvenile court was not responsible, or the juvenile court did not act inappropriately when it passed over a grandparent in favor of an aunt, even though the aunt was lower on the list.
Don't you think Antonio P. is at least equally important for the proposition that it says the placements are to be consistent with the needs of the child? To me, that's the more important part of Antonio P. in the statute, even than the fact that it's not a mandate. Because it draws back to the notion that the intent of this statute is the needs of the child.
That is correct. And there are other statutes as well that say, within Title VIII, that say specifically that DES's goal is to act in the best interest of the child. And so what I was trying to argue with the previous policy issue is that we have conflicting duties that would create as you say, a list of horribles arising from finding that there's a tort duty here.
What about the Sullivan case? Nobody wants to talk about that?
I'd be happy to talk about the Sullivan case.
How does it tie in to the duty analysis, if it does at all?
Well, first of all,
It's a great opinion.
I'll talk about the Supreme Court opinion.
Talking about the one by Downey J.
and Your Honor, if you'll indulge me, I thought it appropriate to pay very close attention to the dissent in this case,
Really?
just to see how it does not apply.
A lot of attention to the dissent, but all right.
What's the benefit of the dissent?
Okay, so I think that the problems that the dissent had with this case don't even apply to our case, because
They didn't apply to Sullivan either, in my view, but that's another story.
Because as you cited from the Hernandez case, the class of persons that this statute or regulation is designed to protect is the child, not the grandparents. And even if you agreed with Mr. Martin that the grandparents are also somehow part of a class of persons that are supposed to be considered, they're not being considered against the risk of the type of harm that occurred in this case. The type of harm they're alleging in this case is their own personal psychic harm from not getting custody of the child. The type of harm that the statutes and regulations are designed to protect are harm to the child.
But it's more than just the psychic harm. It's as you started off, to be close to a grandchild, to potentially raise the grandchild and keep within the general family unit and the benefits that has. So yeah, they're wounded as a result of this, but it's more than, and given the broad notion of family, it's far more than just a psychic wound.
Well, the damages they've alleged are essentially wrote personal injury damages for not getting custody of the child. And I submit that that's something that the juvenile court decided, not DES. But I'm not sure if you were to to try to make the case that they suffered damages during the time space between when the child was born and when the juvenile court made its decision, and that those damages were somehow psychic damages related to being mistreated by DES, being disrespected by CPS. I don't believe those are the types of injuries that the statutes are designed to prevent. The statutes are designed to prevent injury to the child. And I know in this case that one of the things that really has the grandparents upset is that the child did suffer some injuries after adoption. But the child certainly has a remedy herself if she chooses to pursue that now or even in the future after she becomes an adult. This is not the case in which that should be litigated. So in some sense, we all have an obligation to respect each other. And I know that there are people here in this court that feel disrespected. But that obligation doesn't create a compensable duty. It doesn't create a tort duty. And I'm sure there are people at DES that feel badly about what happened to Mrs. Lorenz in this case. It's unfortunate, but there is no tort remedy.
Thank you. And rebuttal, Mr. Martin?
Thank you. The duty owed to Wendy primarily and secondarily to Robert Lorenz is not merely to respect, it is to consider and not thwart their efforts. That duty, by observing that duty, CPS then carries out the duty that they owe to this child. And it's true that there was some harm, and it's been alleged in our complaint, to this child. A little less than a year after the adoption took place. We can't stand here and say that would not have happened necessarily or would have happened. It's speculative, but the fact of the matter is there was some pretty serious harm from this child being placed in that home. And yes, that child does have a remedy up to 2 years after she turns 18, but it's worth observing what happened. With respect to the right of visitation that was alluded to, my understanding of Title 25 is that ends upon adoption. And what was being referred to as a request to have visitation, which is rather hollow because the adoptive parents can simply say no, is absolutely correct under Title 28 under some sort of settlement agreement that is often entered into. With respect to the parade of horribles, I alluded to that in my answering brief, or my reply brief, excuse me, and I would submit that parade of horribles, given the facts of this case, and I'm cognizant of not discussing the facts of the case to find a duty, I get that, but when we cannot completely divorce ourselves from the egregious facts of this case when we think about how to remedy the situation through a narrow, unpublished decision that is grounded upon a reinforcement of CPS's duty to consider. Just consider the grandparents and do so fairly, and don't thwart what they're attempting to do, because by doing that, you're wiping aside and then actually causing some injury to this child by failing to follow through on that concomitant duty that is owed to the parents. So I think that a very narrowly tailored decision could be made to address the problem in this case. With respect to Sullivan, I was prepared to address Sullivan in a word, and I too read with interest the dissent, but cognizant of the precedent of the majority opinion, would urge that it is distinguishable. In Sullivan,
You know, the only point of Sullivan that I thought might be worthy of discussion in the context of this case is the notion that when the court, as a third branch of government, looks at a legislative enactment, we have to look at what the legislature says it was intending to do. We can't say, yeah, but it really should protect these other people, even though that wasn't the legislative intent. And so that's the point of my focus on Sullivan, is what can we divine from the statutes and regulation you've cited that persuades us that the intent was not just to protect the best interests of the dependent child, but to also protect placements against this kind of risk. And so that's the only part of Sullivan that I think has any possible relevance.
understood, and I think one of the major distinctions is that the statutes that we're talking about here governing family placement and giving grandparents, there's just numerous instances in those statutes I cited of giving grandparents a preference and looking to the grandparents, is what distinguishes that legislative body or that group of legislation from that which you were dealing with in Sullivan, which was the subsequent buyer and the economic loss rule. We're not talking about a wall that was built poorly and presented some sort of risk of economic loss. We're talking about the attack on the family integrity here by the very state agency, not a private entity like in Sullivan, but the very state agency that is designed to preserve that family integrity. That's the duty that was violated here.
And if I were a legislator, maybe I would completely agree with that position, but we as a court need to be able to find that that is what the legislature was intending to do with these statutes. So what can we look to for that proposition, not just our own views of public policy, which we all have?
I understand, Your Honor. My answer would be the same as the last time you asked me that when I cited those cases.
Asked it differently this time. I thought maybe you'd answer it differently.
I perceived it as the same question almost, but I would also like to say that I understand what you're saying in terms of these regulations are a non-starter for you, but if I could just quote from what the legislature had to say about these regulations at 8-103B, pursuant to rules adopted by the division or adoption agency shall place a child in an adoptive home that best meets the safety, social, emotional, physical, and mental health needs of the child. And it goes on to talk about other relevant considerations. There's a long list of them. But it says they shall follow the rules, and there's another part of the statutes that says they shall create those rules. I would urge respectfully, Your Honor, that those regulations...
Let's consider them. Let's say they're on
Okay.
par with the statute. But the part you just read, again, makes me think the entire purpose is to promote the needs of the child.
That is the ultimate goal, to promote the needs of the child, but it does not exclude the needs of the parent, of the grandparents, or their so-called rights to be treated with consideration of their ability to adopt and be positioned to adopt and to not work at contrary purposes to that. Doing so ultimately harms the child, theoretically. That's the notion, is that kinship, family placement is preferred. The statutes are replete with references to grandparents and very, very close to the top of these preference lists.
But the parents are the first on the preference list. So
Parents-
you have to acknowledge that if we accepted your view of duty, then any parent who felt like he or she got short shrift from DCS in the placement of their child could sue under a tort claim.
Not short shrift. In my family law experience and some dependency experience, the short shrift notion gets us back to the facts, unfortunately. Yes. But the acts that occurred in this case are unmatched, totally unmatched, in my experience.
The facts of this case, your facts are bad. They're bad for DCS. I give you that. But, I'm trying to abide by what our Supreme Court says on that point.
I understand that, but I would suggest that the consideration, the duty of consideration is there. It's not a duty to bend to the will of the parents or bend to the will of grandparents or tertiary grandparents or otherwise down the line. It's just to give a fair opportunity. And if they don't give that fair opportunity, they should be held accountable, not only for the interest of the litigant, but for the interest of the child as well.
And you would then argue that the opportunity they had at least to litigate the adoption wasn't a duty of consideration?
Their ability to litigate in the adoption trial focused on the best interests of the child and the history that led up to that. That history was skewed and preset by the violation that CPS engaged in of their own rules and the statutes.
So you're saying the duty of consideration would be before that, because otherwise your clients had consideration, appeal that, and unfortunately our court has ruled as it has.
Late in the game, they got some lukewarm consideration, I would submit is what it was. It was just to give lip service to the language of the statute after the horse was already out of the barn and the damage had been done. Thank you, Your Honor.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess pending our next hearing. Thank you.